Okay, our next case is Florida Bar versus Finch, number 2024-0238.
Good morning, Justice. My name is Alex Finch. I'm not sure whether I'm the petitioner or the respondent, because I'm the petitioner. I'm the respondent in the disciplinary proceeding, but I was the first one to file one of the two competing petitions for review. So,
Go ahead.
Okay, thank you. All right. Again, my name is Alex Finch. Good morning to the justices. This is my first time here in this forum, so I hope the water's not too deep and cold. So, this case is about discipline for services rendered during the course of an alternate fee recovery agreement for roofing things. The referee recommended guilt for conflict of interest and excessive fees in the process of representing the client under the alternate fee agreement. I received the clerk's letter indicating y'all have summaries, you've read the briefs. So first, and I thank the court for taking its limited time to take a look at this and try to come to a just decision. So if there are any issues that are particular to this court that you want addressed in this argument, then I would take them now. If not, then I'll proceed to a brief summary. Is there anything
Do you
to
want to start out by addressing, I think a lot of it boils down to the dispute over the language in the statutory attorney fees section of the fee agreement. And do you want to address the argument that the fees voluntarily paid by the insurer in the context of that provision stand as a contradiction to attorney's fees awarded by a court, and it wouldn't include the types of fees where the types of fees in these three fee agreements are at issue in the case?
Okay. First of all, Your Honor, all the decisions of this court, First Baptist of Cape Coral, Florida's Compensation Fund versus Moxley, Strems, what they all stand for is if you have an agreement that has an alternative fee within it, and that one of those alternatives is utilized, then it's permitted. All those cases that didn't have the voluntary payment from an insurer, they all said things like a contingency and or statutory fees awarded by a court. And so in this court's decisions in Kavanaugh and Florida Bar versus Strems, you made the court made a particular distinction that if you get voluntary payment from a source, that is not a court-awarded fee, and there's no argument here. Here, the agreement specifically sets forth three methods of payment: contingency, court-ordered payments, and it says voluntary payment negotiated with an insurer. And in the roofing claim industry, all these hurricanes and hundreds of cases, that's how cases resolved. You negotiated with the insurance company, they determined what amount they wanted to pay as a fee, so you did not have to go to the court. And their releases, in the three releases in the Puckett, Atkinson, and Haas cases before the court, all required confidentiality. They don't want people knowing what they're paying out on indemnity or on attorney's fees to the plaintiff's counsel. So I would suggest to the court that there's not a contradiction for those fees. It's just another alternative method of payment that was specifically requested by the client and the chosen option for the client. That's how he wanted it handled. Get him, I'm sorry, it's a company, get its desired, stated recovery, and then go to the insurance company and get paid so I don't have to pay you my 10%. And that whole agreement, all through it, indicates just that. The client got a dollar-for-dollar credit to increase their fees, not to reduce them. And fees weren't taken from it. They were credited, so they got everything, and it came from the insurance company to maximize the client. So there's no fee taken from the client So therefore, there's no excessive fee, and there's no complaint by any insurance company as to the manner in which they chose to settle any of their claims. And there are a lot of these. There are 160 claims altogether. That's how I address that. I don't think it's a contradiction. It's just an additional agreed upon form of compensation that's not prohibited by any decision of this court or the rules regulating the Florida bar.
Counsel, you've been involved in the insurance field for a while. So do you know what a reserve is? Do you know when an adjuster establishes a reserve?
I've been involved in the insurance industry for roofing claims since about 2018. General personal injury, mass claims, that sort of thing that deal with reserves and all that. I don't have a great deal of, I have a rudimentary knowledge of it.
Well, when an adjuster gets a claim, an adjuster typically establishes a reserve, right? That's the amount of money that they estimate might be necessary to pay on a claim, right?
Yes, sir.
And that's typically what an adjuster is negotiating off of, right? When an adjuster gets an offer from a lawyer like you, they're looking at the number that they have, their total authorization to settle that claim. Right.
Yes, they say we have an authored amount on the claim, but in negotiating beyond the claim, they have fee exposure under that statute. They have fee exposure under multipliers before the court for contingent component cases, and in contract cases, this court has held that you can get a multiplier. They're aware of that, so they deal with their reserve amount they have available, but that's as to the claim, not as to fees beyond. That's my experience in negotiating these cases.
But I think that's where Justice Sasso was going a little bit with the initial question is, but we're not talking about the statute for you. You're talking about this fourth category, which is just kind of voluntary. So the insurance company will negotiate, I guess, a settlement or a payout for your client, and then you're going to be asking them to pay your fees, which is typically going to be a benefit to the client because the insurance company's they're not getting a service from you, so they're not paying you for your service. They're paying you as a recovery for your client, right? Outside the risk of having a prevailing party or some sort of court hearing where there's going to be determination of entitlement to fees.
Yes, they treat insurance fees as an obligation they might have under the various scenarios you just gave, Justice Tannenbaum, but they negotiate them in these roofing cases separately. They don't combine it together. If they do combine it together, that's a global settlement and all the types of things that Justice Sasso is concerned would come out. Here, we're going to give you $100,000 divided up amongst yourself.
But it seems that in this context where there's not a suit necessarily, I mean, you're just calling, and I mean, it's an AOB. This is AOB world, which is a whole other world from typical lawyering. It seems like from the insurance company's perspective, they just want you to go away. They want this claim to go away. And they have a certain amount of money in their pot for this claim. And if some of it ends up having to be paid to you to make you go away on top of your client going away, that seems to be, that's where the conflict potentially comes from.
Well,
isn't
no,
it?
Your Honor.
Because you're,
I'm sorry,
if the insurance company weren't paying you as much for this fee, which is like not even established, it's not your rate, it's not a contingency, it's just some number, I guess, that you're coming up with. That's money that could have been paid to the client instead. So you end up negotiating against your client.
No, Your Honor, because in all these cases, when settled and not settled for this client, the client set their RCV, replacement cost value indemnity demand, what they wanted, settle their claim. They told the attorney, I want $100,000, whatever it might be. And the attorney was directed to go get that and get them what they wanted or they found acceptable to pay their claim, and then specifically directed the attorneys, and go get what else for you so I don't have to pay you my contingency. Now, if those two components fell within the insurance company's reserve for settling that claim, then it's settled. But there was no instance in any case in the record for the court at all where the client's requested and demanded RCV amount was reduced by $1 from what the attorneys were able to negotiate with the insurance company separately. So there was no conflict because the client controlled the amounts of the settlement, what they wanted for the settlement, what they accept for the settlement, and they made a business decision as to what their claim was worth to them and did not care what the fees were.
And is that, or were there findings on that? Because it seems like part of the issue here is how much, part of it is just, is there an inherent problem with this kind of arrangement, which that's one thing. But then the other aspect of it is, did the client and you, did they have full visibility on how that was working out? And what was the finding? What was the finding on that by the referee?
Well, he didn't make a specific finding within his recommendations or at court. The evidence was that the principal for the client and both attorneys spoke with the client on his cases every day, 4 in the morning, midnight, had unheard of access to his attorneys. He got emails. He set the negotiation parameters except for fees because he didn't care. It was negotiated, and he made the decision on whatever the ultimate amount was. There was no lack of communication, and the only 2 communication issues they reflect in the order was 2 emails discussing how fees were sought against an insurance company and not the client. And the referee found those to be ambiguous and found them to be self-interest motivated.
What was the dispute, though, that led to the client to file issue the complaints against you? I know the bar is the one that ultimately does the complaints.
Yes, sir.
Obviously, at some point, the company cared about what.
Yeah, he became unhappy.
Yeah.
About a year and a half into the thing, and he started saying you're limited to 10% under the agreement, and that is not what this agreement says. It's a contingent agreement, and all forms of compensation aren't limited by that 10% contingency under the court's ruling in First Baptist and Coral and Moxley. When the attorneys refused to continue doing services at that, or to back charge and lower it, the client got exceptionally angry and wanted the attorneys to continue giving services at what he decided to modify the agreement unilaterally. The attorneys did not want to do that because it wasn't cost effective. So he became angry, pulled cases, and we decided it was no longer a good client relation. It was adversarial, and we terminated the relationship. He became incredibly angry then, saying, all these cases, your name's on them, you have to keep doing them even though you don't want to. And that resulted in 7 bar complaints, some from his clients, some from him, friends, 2 malpractice actions, numerous actions for charging liens, things of that nature. But that was the impetus. For whatever reason, he wanted more for his claims, and he wanted to go backwards and say all these things I agreed to, and I determined and I said I'm going to change them all and give me back everything so that you only take 10%. Even though the money didn't even come from him, it came from an insurance company. They were attorney's fees, and the client was not a licensed attorney, and we obviously couldn't share fees with that client. But that was the genesis of it, just as meanness.
Okay. You're down to a minute left into your rebuttal time, so.
Okay, well then I would reserve the balance of the rebuttal.
Okay.
And I thank the court for its questions and its opportunity to review this matter.
Okay, thanks.
Thank you.
May it please the court, Mark Mason on behalf of the Florida Bar. We're here today on a case involving an ongoing conflict of interest and a lack of adequate communication between lawyer and client regarding the amount of fees. Intentional misrepresentations in 2 of the cases that were addressed in the briefs by Mr. Finch to his client regarding the amount of fee he was going to retain on cases. and not a single closing statement provided. I heard in the argument that, well, this was the chosen option for the client. A lot of this would have been resolved if there were closing statements here that clearly explained the disbursement of funds as they came in. A lot of this would have been cleared up if lawyer and client communicated regarding the amount of indemnity sought versus the amount of attorney's fees sought and the way that was done. But that's not what happened.
So is there a problem structurally with that, with the agreement itself? Because I mean, some of this is there. I mean, obviously, there's one way of looking at this is that there's an inherent conflict of interest because there's just one pot of money, and if the company doesn't care how it gets divided up, then So I guess what's your position on that?
Regarding the fee agreement itself, there was potentially a way it could be interpreted where there would be no conflict. If the statutory fee provision that's being referenced is read in the context of, say, there's an order entered by a circuit court.
Okay, that's
yes,
obviously,
sure.
But on the issue of the agreement,
voluntary paid.
Right.
Yes. Voluntary paid in that context of a statutory fee provision, which is titled a statutory fee provision, it could be read as court order, entitlement to fees, reservation of ruling as to amount, and then it's voluntarily paid before there's any court order against the insurer requiring payment. There would be no conflict there because at that point, in my mind, you're negotiating only that order, only that attorney fee, and it wouldn't necessarily affect the client's bottom line.
But what about the way that it was being used here?
The way it was being used here necessarily affected the client's bottom line, because what happens is they go to the client, and the client says, I want $50,000 RCV, that's replacement cost value, all right? And sometimes you'd be flat out asked, what's your bottom line? And then the lawyers would take that number to the insurer and said, this is my client's bottom line. There are emails that use that exact language, immediately sharing bottom line numbers with opposing counsel, and then tacking on an attorney fee that just so happens to always average out to around 20% of what would have been a global settlement offer. So, you can call it under a different label, but what this really is trying to collect a 20% contingency fee when the agreement says 10% contingency fee. And it necessarily affects the client's bottom line because Justice Tannenbaum mentioned it earlier. The adjusters are just trying to make these go away. They want the attorney gone. They want the roofing company gone. Totally understandable. They're concerned about the overall amount they're paying to get their release and move on to the next case.
So is the issue, though, whether there's full sort of transparency with the client, or should the bar say, like, you cannot have this kind of an agreement, period, because it's so fraught with the possibility of this conflict?
Right. Both. Obviously, there's the inadequate communication rule violations, which you need to have disclosure, and that would have mitigated a lot of the harm here because this was a 2-year lawyer-client relationship, and that was kind of an extended harm. As to the fee agreement... So
if there had been adequate communication, would it have been okay to say, hey, I'm going to go try to get your RCV, and once I get that, I'm going to negotiate the fee, and as long as you're okay with that, would that be okay? I mean, don't lawyers deserve to know from the bar whether that's okay or not?
Right. No, I understand that. And if there was a complete disclosure with the client and the lawyer, and the client clearly understood, you're capped out at this number, I'm now negotiating an attorney fee to try to get more, I think that would be a completely different set of facts than what we have before us today.
And including in that communication the fact that, and that money might come out of the pot that could be available to settle your claim and get you more money.
Right. And that's within the conflict of interest rule itself, is that the client needs to give informed consent. Certain conflicts are not waivable. And so there would have to be a significant amount of disclosure before we're approaching an agreement between lawyer and client where suddenly this is an acceptable agreement. But as to the sanction itself, the referee recommended 90 days. But the referee also found certain facts that suggest this needs to be a rehabilitative suspension. And by that I mean there was a specific finding that there was clearly misleading and intentional communications that was made during the referee's oral ruling, And when the referee was addressing the Atkinson case and Mr. Finch's email to his client stating he was entitled to $13,000 in fees, when if there was an acceptance of the settlement offer, he admits now that he would have only entitled to half that. So there's the dishonesty. Then there's the ongoing pattern of misconduct here and the multiple offenses. 10 rule violations. I'm not even getting into the ones that are not disputed today. We're only talking about the most egregious misconduct. But it's 10 rule violations spanning a 2-year period. And when you're dealing with this situation of a lawyer who's prioritizing his own financial interest over the interest of the client, this court has said in Morrison that is an intolerable breach of trust. And it's very difficult to square all that language from this court's prior opinions in Morrison, talking about dishonesty in the head opinion, and squaring that with a 90-day suspension. When we have an opinion of this court from about a year ago, Alva, which involved a similar issue of a lawyer trying to take an excessive fee and becoming adverse with the client, in which this court suspended the attorney for 1 year. And for that reason, the bar is asking for 1 year. I have a bunch of time left. I'm willing to reserve that unless I have any more questions. Yes.
Another question. So the legislature's been trying to deal with the AOB field for a while. I mean, it's a shady area. I mean, put that aside. Is that something that we can take into account in terms of whatever the discipline should be? I mean, this client is not the 80-year-old, female client that was mentioned in one of the cases. I mean, this is a construction. This is a roofing company. They're trying to get these payments from insurance companies under AOBs. They know what all of that is about, and they have a lawyer that's helping them out on this. Does that matter?
I don't believe it does. And the reason I say that is AOB claims can be subject to an enormous amount of dispute on how much money they have cost, how much fees they have drum up, and how it's incentivized construction companies to go door to door and get people to sign on for repairs they don't need. I understand that concern of it, but at the end of the day, Mr. Finch did what he was allowed to do, which was represent the roofing company pursuing those assignment of benefit claims. Now, as for vulnerability of the victim, and this not being an 80-year-old woman, I know the referee found multiple times that this was a sophisticated businessman, and that somehow that's mitigating. It's not, because at the end of the day, this businessman relied on his attorney to handle a substantial amount of money for him. And what the attorney instead did, rather than abide by the fee agreement, rather than explain to the client how much money was being taken, was he just set an arbitrary amount of fee and kept it for himself until the client eventually complained. The client may not have been the 80-year-old woman, but he was in a vulnerable spot by having someone handle the money for him for that long period of time, and for that to happen to him. So for that reason, I'd still ask that be considered no mitigation at all, really, and a 1-year suspension imposed.
Having kind of been in the weeds on this yourself, do you think that the rules need to be clarified or changed to kind of specifically address this kind of arrangement? Because I understand, I completely understand, the findings here about potentially there having been dishonesty and everything, but it seems like there's just kind of this is like an inherently sort of gray area as far as putting the conflict of interest construct on it and everything. And so it seems like we need to think about kind of clarity and predictability and notice to both lawyers and clients about whether these things can be allowed. And it just seems like some of the arguments you're making would be there even if there had been complete transparency here. I mean,
correct. My default answer to can the rule be amended is...
Well, I know it can be.
I didn't mean it like that. I'm sorry. It's very hard to create a rule. It's going to draft every single type of it's going to contemplate every single type of agreement that a lawyer might create with a client. And I don't think there's any notion that we want to discourage a fee structure that would be necessarily acceptable. But part of that's the reason we have an ethics hotline at the Florida Bar to bounce questions off of. 4-1.5, which is about the contingency fee agreements, is very long already. It's one of those rules that does get amended to address specifically what needs to be involved. But yes, I believe we'd be in the same situation regardless of whether the rule was amended, just because of the lack of adequate communication going on here, and specifically a lack of closing statements, which just made a bad situation worse.
It would seem to me that that's really your answer, is that if he had provided the closing statements, then this would have been detected by the client immediately, so no rule change is appropriate. Like that seems to be the core bottom line breach. We wouldn't be here if you had delivered timely closing statements, right?
I imagine that this would have been resolved between lawyer and client very early on,
right,
if that had happened.
Right.
But it doesn't solve the problem of, so there'd be a closing statement, but the client's not necessarily aware that the lawyer is negotiating basically a side deal that could come at the cost of the client, and they may not be aware of it. I think that's the point. You're here asking for a year suspension for a variety of reasons, which then turns out, are you trying to make Mr. Finch a test case in a way, and then everyone else will know that there's a lot of risk with these agreements, as opposed to doing something affirmatively. I mean, there was already this long thing about the contingency agreement. There could be something shorter that explains, so that lawyers know that there's a lot of risk, there's potential conflicts of interest just inherent in this type of arrangement.
Right.
With the goal being, the goal is never to make sure lawyers get paid. The goal is to make sure that the public has access to adequate representation. So, this voluntary agreement is not necessarily necessary to make sure the public has access to one of the over 100,000 lawyers we have in the state of Florida.
Well, yes, and one of the main purposes of our discipline is to act as a deterrent for others. And when you have something that's going on for this long of a time, and it's not just, I maybe interpreted the agreement a little more liberally than I should have, but literally the client is raising these concerns constantly. And the response isn't, let's meet with the client and discuss, but instead is to say, well, this is what we're going to take, this is what we're entitled to. Just keep calling them statutory fees and just mislead the client with these emails saying I'm entitled to a third when that is not established anywhere whatsoever. This is the conduct that needs to be deterred through a really rehabilitative suspension, not just an innocent misinterpretation of a fee agreement that just so happened to create a conflict of interest. And that's one of the main reasons the bar is seeking a 1-year suspension. I'll reserve the remaining time for rebuttal, cross rebuttal.
Thanks.
Thank you. I'll try to be brief.
What's your answer? Yeah, go ahead. What's your answer as to the closing statements? I think it sounds
that's
like
where I was going.
Yeah.
The closing statement is to advise the client of the settlement of the case and the terms, so he knows what a lawyer gets and what he gets or it gets. In this case, there were the client was directly involved in every single settlement, emails back and forth, where he determined what he would get for his claim, and sometimes what the attorney fee amount would be, because in the email it said, we're seeking this amount of money and this is what it's going to be settled on. Do you agree? We treated that as serving as the purpose of the closing statement, rightly or wrongly. But the client had knowledge of all funds he was getting, had demanded an amount for a claim that he wanted, and he knew what the attorney fee got, signed a release for it, and then, and then took his funds and left it the other way. And the funds were paid in separate checks, except for I think about 8 cases where it came in a global one check. So the purpose of the closing statement was served. He wasn't a neophyte who didn't know his case. He managed them. He managed hundreds of them with our firm and other firms. The bar wants to require you can only get fees other than a contingency through court order. That's what they say in their briefs. That's what they argue here. And that's what was just said in oral argument. Well, that's Kavanaugh. and that's Strems. Judge Munoz says there could be an inherent conflict here. This court has ruled in Strems, in the footnote, there is no inherent conflict by going and getting fees separately from the client. It's how the agreement is applied. Sorry, excuse me, Your Honor. And here, there's no facts where it was applied to the client's detriment. He always got what he wanted. The bar argues if he wants $5,000 for his claim, we're supposed to say, no, you should take 20. You should take 15. But the rules regulating Florida Bar 4.1 and 4.14, which this court addressed in Strems, says we have to honor our client's directions. If he wants to settle for $1 or a penny, that's what we go get. And that's what happened in every case. Not a single case of the 160 settled ones did that not happen. Did that client pay us a contingency of a penny unless they accepted a proposal for settlement and cut off the right to negotiate with the attorney. And they said, okay, we don't want you to do that. We're going to pay the 10%. Let's get to sanctions. This court sanctions in the Davidge case just a couple of days ago. You upheld a 90-day suspension on an alternative fee agreement for conflict of interest. Well, that was playing against two people, a roofing company as a client and the homeowner. And you gave them 90 days. That was intentional conduct. What you have here at best is a misrepresentation, a miscommunication. I talked to the client incessantly and fully and gave them the opportunity to do what they chose to do, and then we had adhered to their instructions. The Atkinson email, the Haas emails, they were all in the context.
Can you direct us to anything in the record of the client's testimony stating that they felt adequately informed?
No, because what the client said was, I didn't read what was sent to me. I didn't read the emails. I just trust my attorney. But when you looked at the emails, they were all to him. He came back with statements like, just get me, whatever, $50,000 and go get your fees. He was not credible as a witness. He said he didn't even see the agreement. It was mailed to him when the attorneys went to his office and explained it to him and signed it together in front of him. So he didn't say, I guess he probably did say I didn't know, but he didn't know because he says he didn't read anything sent to him. And there are reams and reams of emails back and forth. There are text messages back and forth discussing each claim for that client to make its determination of how it wanted to settle the claim. And we followed that instruction under 4.1 and 4.14. There is nothing in the record anywhere where the law firms took in excess of 10% from the client. And there are only 8 cases in the entire record where we even took 10% from the client. Everything else was a separate payment from the insurance company specifically to relieve the client of their 10% obligation to us. Client didn't want to pay 10%, so they said, go get your fees somewhere else. We did so. So in the suspension type things, and Kavanaugh, Unilateral Act, taking money, not telling the client, but Mr. Kavanaugh thought he had good faith belief. The Kavanaugh court said good faith dispute over entitlement to fees doesn't constitute a conflict of interest. There might have been an excessive fee, and they told him to pay it back, and they gave a reprimand because it's a miscommunication between the client and the attorney. And that's all you have. You have no active misrepresentations, no untruths in any emails anywhere. And I would respectfully suggest that we followed the agreement. My partner and I followed the agreement and our client's instructions to the T. So gnosis punishment is really due for the Atkinson and Haas. There's an issue with the Puckett, my client, in a time of great stress in his life, losing a sibling, didn't provide a settlement offer, and you made a mistake. Attorneys aren't perfect, including me and my partner. But even if you found that it was a miscommunication and the emails not being clear enough, it still doesn't rise to a level of rehabilitation by this court's ruling. When there's active unilateral conduct, misleading people, lying to them, then yes, that conduct needs to be handled. That attorney needs to be punished and needs to demonstrate. They're not going to do that again. But you don't have it here. It's nowhere in the record. There's nothing to rehabilitate either me or my partner. My partner has a companion case that's still before this court, and they travel together, so I imagine this will have an impact on that. So it's just not there. There's no there there. The bar wants to cast things down and say, well, you took your client's money. Well, clearly we did not. You lied to your client. There's no evidence of lying. There's only 2 emails that they say are unclear. Okay? Unclear isn't lying and intentionally lying to hurt your client. There could have been a miscommunication. This court's rulings say that's a public reprimand.
Okay, could you take about 30 seconds to wrap up?
Yes, sir. Yes, sir. In conclusion, for the court, the agreement's valid. There's nothing saying it isn't, and we operated under that agreement. There may be gray areas, there may not. But it's a valid agreement under all this court's precedent and the bar rules. We followed our client's instructions to the letter in getting him what he demanded for his claim. Always. No exceptions. Ever. We did not know that there was a complaint as to these settlements until 2 years after we were representing the client. So there was communication. There wasn't continued representation during a period of time where we had knowledge of a problem with any of these cases that were brought. Okay. 2 years later. So thank you. Again, thank the court for its time and considering these issues and granting me the opportunity to speak. Thanks. You.
Very quickly, I heard a lot that the client always got what he wanted. The client testified that he provided a bottom line, and it was his expectation, just using the term bottom line, that the lawyer would try to get him as much money as possible. He just had authority to get to that bottom line. So when you hear the argument, the client always got what he wanted, that's what that means, is that he got the bottom line. As for there being no untruths in the emails, that was not the finding by the referee. The referee explicitly stated, it's on page 10 of the referee's report, that there was a clearly misleading intentional violation of the bar rules, and that had to do with his claim to $13,000 in attorney's fees in Atkinson when he was only entitled to half that amount of money. The client rejected the offer, and the client got a lower amount of money as a result of that email. And just overall, what we're talking about here isn't mere negligence. The referee found otherwise with regard to that email specifically, but also just generally, when you know the client is complaining and you're not doing this meeting, you're just plowing on through with the way things have always been for this 2-year relationship and saying, well, the client never complained about it before, why is he complaining now? Because the client learned about it. That's the reason. So I don't know how mitigating that really is, but certainly, in Strems, it was obviously a lot more in Strems was happening that resulted in disbarment. Only a portion of that case is applicable, and it had to do with Strems trying to retain a fee that was way above and beyond what he was entitled to under the fee agreement. That was one case. This court said that alone would warrant a 1-year suspension. When you combine that with Alva, which I mentioned earlier, another 1-year suspension case, the bar sanction is entirely appropriate with what this court has said about excessive fee cases and intentional dishonesty cases. If there are no other questions, thank you for your time.
Okay, thank you. We're adjourned for today.
All right.
This honorable court is now adjourned.